I hate to break it to you, but if you own a gun and smoke weed, you're a federal criminal. I don't care what your trust me bro friend told you at the range. I don't care if you have a med card, and I certainly don't care about rescheduling. Under federal law, you're a felon. And it's been that way since October 22nd, 1968, when Lyndon B. Johnson signed the Gun Control Act in the middle of the most paranoid year in American history. America watched JFK, Martin Luther King Jr., and Bobby Kennedy all get shot on camera. This one law put cannabis users in the same boat as federal fugitives and felons, a box they have never gotten out of. But that could finally all be changing in a few months because of a guy named Ali Hemani. His case about guns and cannabis is sitting in front of the Supreme Court right now. The decision drops in a few months, and it could either kill this law, narrow it, or lock it in forever. Stick with me, because by the end of this video, you're gonna understand the one statute that turned millions of Americans into paper felons, and how all that could change very soon. But to fully understand why a guy in Florida with a hunting rifle and a med card in 2026 is considered a federal felon, we have to go back in time to one of the most paranoid years in American history. November 1963. President Kennedy shot in Dallas. April 1968, Martin Luther King Jr. shot in Memphis. June 1968, Robert F. Kennedy shot in Los Angeles. 3 of the most important men in America killed on camera in 5 years. 4 months after RFK gets shot, they passed the Gun Control Act of 1968. Buried in the middle of that act are people who can no longer legally own a gun. Felons, fugitives, and people who were committed for serious mental health adjudications. And remember this because this is important, this section is labeled 922G3. Any person who is an unlawful user of or addicted to marijuana or any depressant, stimulant, or narcotic drug. And this is so old that it's spelled with an H. Marijuana is spelled with an H here, guys. Like I said, remember those numbers, they show up a lot throughout the rest of this video. The thing is, there is no definition of what an unlawful user actually is. No dosage, no time window, no frequency. A guy who took 2 hits off a joint a few weeks ago is the same as a heroin addict with an AR, according to this law. Same felony, same prohibited class. This law wasn't written for cannabis users, it was written amidst a panic, and marijuana users just happened to get swept into it and never got swept out. Ever since this law passed, there has been a long history of people going to court trying to get their gun rights back as cannabis users. Here's how that went. After the court's 2008 Heller decision, which confirms the Second Amendment, protects an individual's right to own a gun, cannabis users started challenging 922G3 in court, and it didn't work. Here's how it went. A regular smoker in Indiana with a rifle and no violent history loses. A longtime medical cannabis user in Virginia loses. A woman walks into a Nevada gun store with a state-issued medical marijuana card. Guess what? The ATF blocks the sale and says the card itself is proof that she's an unlawful user of a controlled substance. She sues and loses. Sit with that for a second. The state of Arizona says, yes, you are proof for a medical marijuana card. The feds look at that same card and say, hey, that's proof of a felony. That sounds an awful lot like the Marijuana Tax Act of 1937. Get your paperwork, follow the rules, and the government will use it against you. Every circuit, same result for over a decade. Enter New York State Rifle and Pistol Association v. Bruen. This one court case set the precedent for cannabis rights and gun users, but not in the way you'd think. Before Bruen, courts asked one question: is this gun law reasonable? And under the guise of public safety, the answer was almost always yes. After Bruen, however, the question is different. Does this law fit within historical firearm regulation at the founding of our country, which made the government actually have to find examples from 1791 or the Reconstruction era, showing that this type of person is traditionally disarmed. That's a massive problem for a law that bans any unlawful user of a controlled substance forever. Because there was no DEA in 1791, there was no Controlled Substances Act, and there definitely was no tradition of disarming people for what they did in their free time with a plant. The government needed a historical analog, and they didn't have one. Enter Patrick Daniels, Mississippi, pulled over for a missing license plate. Officers smell marijuana and find a few burnt joints along with a few loaded pistols. Daniels says he smokes roughly 2 weeks out of every month, or every other day. He wasn't high at the time of the arrest, he was driving fine. The missing license plate was the only reason for the stop. And what did they charge him with? You guessed it, 922G3. His defense, after Bruen, is simple. Show me where in 1791 the founders of this country disarmed a man for smoking a plant in his free time. They didn't. And believe it or not, the Fifth Circuit, Texas, Louisiana, and Mississippi, not exactly the most cannabis-friendly part of the country, ruled in favor of Daniels because the government couldn't find the evidence they need because it didn't exist. What this case did was monumental. It cracked the lower courts wide open, created a circuit split, and finally made the Supreme Court do something about this law. But real quick, just because we have to touch on it, before it got to the Supreme Court, the most politically radioactive defendant ever got charged under 922G3. Have you guessed it? It's Hunter Biden. Believe it or not, this is not an ad. Since I started posting content again, YouTube has started age restricting and removing some of our old content as well as even some of the new content. So unfortunately guys, I will no longer be able to show bud on the channel. They think I am trying to promote the sale of a legal or regulated good. Any content that YouTube censors will be free on Patreon. You can find us at Couchlock News. Link is there as well. I'm not making you pay for something that's not your fault, but if you want to support us, the first 16 people to subscribe for $5 a month will get these 16 t-shirts for free. A few years ago, right before I stopped making content, this guy right here made us a batch of t-shirts out of the kindness of his heart. He did it completely for free. If you need any kind of graphic design t-shirt work done, hit up Rory. His Instagram and details are above. We aren't doing a reprint or any t-shirts anytime soon, so these are truly one of a kind. If you subscribe to the Patreon, you'll also have access to an entire backlog of our content, as well as completely ad-free content, censorship-free content, and we'll be able to interact 1v1 if you have any ideas, things you want me to look into, etc. Thank you guys so much for all the support. It has been overwhelming over the last 2 weeks. You guys are the best, and I can't wait to continue to build a like-minded community here on YouTube and across the internet. Back to the video. In October 2018, Hunter Biden walks into a gun store in Delaware, buys a revolver, ATF Form 4473, the federal background check. Question 21 asks if you're an unlawful user of any controlled substance. He checks no. In his own memoir, written before any of this, Hunter describes in his own words being in a severe crack cocaine addiction during this exact time. In June of 2024, Hunter Biden is convicted on 3 counts, including 922G3. And in December of 2024, he is pardoned by his father, Joe Biden. So the son of the president gets to walk out of the door and escape 922G3, but millions of Americans who are medical card abiding citizens risk the chance of being locked up for a very long time, or at the very least an expensive court battle. All of this, ladies and gentlemen, brings us to the case sitting in front of the Supreme Court right now. Ali Daniel Hemani, Texas, 2022. Agents find a Glock, about 60 grams of marijuana, and a little bit of cocaine. He admits to regular use and is charged under 922G3. Post Bruins and post Daniels, the courts rule in his favor. There's still no historical precedent, and you still cannot justify a lifetime ban. The DOJ then appeals. October 2025, the Supreme Court takes the case. March 2nd, 2026. Oral arguments start, and good news, multiple justices pushed back hard against the government here. They asked how broad unlawful user of a controlled substance actually is. Whether Congress just dumped the entire drug schedule into a gun ban without ever deciding which substances really create danger. They questioned if any historical traditions exist like this. And finally, they asked, is unlawful user so vague it basically invites the government to selectively enforce it against whoever they want? The decision will drop late June or early July of 2026. So the question on the table is, can the federal government permanently strip your gun rights because of what you put in your body with no proof you've ever harmed anybody? By my analysis, there are possibly 3 paths this could take. Path 1, uphold it. Categorical ban on all drug users stays. Med card users who followed every rule, federal felons. Path 2, narrow it. The government can disarm people who are actually dangerous, armed while impaired, and have a documented violent history. But it can't sweep peaceful cannabis users into this bucket, and Congress is sent back to write something that actually makes sense. Path 3, strike it down completely. 922G3 fails all of these history tests entirely. The whole framework collapses and nobody in Washington gets to pretend like they didn't see this coming. So now let's get to the fun part. Let's get to the numbers. How many people does this actually affect? Well, I'll tell you. 32% of American adults own a firearm, roughly 100 million people in our country. 22% of Americans 12 and older used cannabis last year, over 60 million people. Fun fact, there are now more daily cannabis users in America than there are drinkers. Those two groups overlap massively, meaning there are tens of millions of Americans who, on paper, are federal felons. And the thing that a lot of people aren't talking about is that if the hemp ban goes through, a lot more people are going to be added to that list. And some might not even know it. Delta 8 gummies, Delta 10 vapes, THCA flower, grocery store seltzers. Products that stay under the line but absolutely get people high will now fall under a federally controlled substance if Congress decides to go through with the ban that they passed in late 2025. When that clock runs out, everyone using those federally legal products is now a felon as well. So here's the news cycle people are confused about. On April 23rd, 2026, thanks largely to our girl Kim Rivers, the acting attorney general and the DEA moved two specific categories of cannabis from Schedule 1 to Schedule 3. FDA-approved cannabis products and state-licensed medical marijuana products. Cannabis is now finally on the same federal tier as Tylenol, codeine, and ketamine. And the first time the feds have actually admitted that cannabis has some sort of medical use. But despite all the headlines, it really fixes almost nothing, especially when it comes to gun rights. See, Schedule 3 is still a controlled substance, and the federal gun ban runs on one question. Are you a user of a controlled substance? If yes, then you're prohibited. So your med card is still living proof that you are an unlawful user of a controlled substance. And if that sounds familiar, it's because it should. Because in 1937, the government passed the Marijuana Tax Act, which made you register with the government to sell and use weed, but at that same time, you were admitting to using a federally illegal substance. Gun rights and med cards in 2026 work very similar. Get your card legally, tell the government who you are, and be classified as a felon. Rescheduling saves cannabis companies money on taxes, and that's it. It doesn't give a single cannabis user their Second Amendment rights back. It doesn't change Form 4473, and it does not stop a single ATF prosecution unless you're Hunter Biden. And here's the part that should make every gun owner mad despite how you feel about cannabis, because the whole point of this law is to protect people. It's to disarm someone that could be a danger to others in society. If you were to actually ban one substance that promotes violence in our society, and it's linked to that statistically, it would be alcohol. Domestic violence, bar fights, aggravated assault, DUI deaths, the numbers with alcohol have been consistent for decades. Cannabis, on the other hand, in some cases, high use correlates to more violence, but across the general population, there is no link when you control for poverty, mental health, and prior records. But federal law gets this completely backwards. Guns in a six-pack, you're good. Have a state-issued medical marijuana card recommended by a doctor, felon. So strip away the case names and the statute numbers. If you were a cannabis user, if your doctor recommended it, if you followed all the rules, are you a full citizen with constitutional rights? Or are you someone the federal government can disarm at will for what you choose to put in your body with zero evidence you ever hurt anybody? And I am by no means arguing that every drug user should have a gun. If you are violent, if you are impaired, there are laws for that. I'm saying that a blanket lifetime ban for millions of peaceful, legal, law-abiding Americans based on a 1968 panic law with zero historical precedent is not a public safety policy, it's a paperwork trap. The same one the Marijuana Tax Act ran in 1937. Different decade, same country, same trick. Hemani will finally answer this legal question this summer. What Congress decides to do tells you just how serious we are about equal Second Amendment rights in this country. Because if cannabis makes you too dangerous to own a gun and a six-pack does not, the problem isn't public safety, the problem is a law stuck in 1968 and reality doesn't seem to care.